Julie?
You're live, Judge.
Okay. Okay, let's go ahead and proceed.
Good afternoon, Your Honor. Christopher Provost on behalf of Latasha Miles. May it please the court.
You may.
Your Honor, we're here on behalf of plaintiff's motion to strike the controverting affidavits of Dr. Sklar and Dr. Pettibone. And then after that, we also have a motion to quash to possibly address.
Okay.
First, Your Honor, we filed this motion to strike back and had it set for an actual hearing at the end of May. Originally, we were in the waiting room for our hearing, and plaintiff's counsel and defense counsel were able to come to a Rule 11 agreement in which defense counsel agreed to withdraw the controverting affidavits of the two testifying experts that were designated. However, the deposition for the defense expert, Dr. Sklar, still went forward as scheduled, which was a deposition which was agreed to and scheduled prior to the first setting of the motion to strike, as well as the Rule 11 agreement. To kind of get back to it, Your Honor, we had filed this motion to strike specifically for Dr. Sklar regarding his conclusory statements and his reliance on mere ipsa dixit alone. In the original controverting affidavit filed by Dr. Sklar, he fails to even state, outside of providing a CV, the basis of his expertise. Dr. Sklar does indicate that he's reviewed the bills and records for the services that were produced and received by my client, and provides conclusory statements specifically outlining that those services were somehow unreasonable and unnecessary in light of the medical care that was provided. He doesn't, as I stated originally, he doesn't describe the qualifications in his controverting affidavit. It's not until a supplemental controverting affidavit is filed that he does outline his expertise or qualifications. In that supplemental controverting affidavit, the doctor specifically addresses future medical care, which is something that is outside the scope of the 1801 affidavits, Your Honor. Outside of the failure to show any qualifications as to his background and expertise for reasonableness and necessity, the doctor also fails to provide or obscures the basis that he believes the medical care is unreasonable and unnecessary in very conclusory and...
Can I ask a question? Maybe I missed something in here. So I thought you said that he withdrew the counter affidavits. Why are we discussing all of this?
And Your Honor, we are here because though the Rule 11, which opposing counsel has refused to sign, but rather we have an email exchange prior to the attending of the original hearing, counsel still presented Dr. Sklar for testimony relating to reasonableness and necessity at a deposition which occurred at the end of July.
Okay, let me hear from opposing counsel.
Can you all hear me?
Yeah.
That's right, Your Honor. We did agree to withdraw the counters. I believe it was on May 22nd. But there was never an agreement that Dr. Sklar wouldn't give a deposition. We just agreed to take away his counters. And I don't believe just because we did that, that precludes us from deposing the expert.
I agree with you.
And Your Honor, I specifically would like to point out that there is case law that says to the contrary through the Fifth Court of Appeals, Ten Hagen Excavating versus Castro and Lopez. Either if the controverting affidavits are struck or not presented timely, the doctors cannot then present testimony as to reasonableness and necessity, either in deposition.
But he can still testify about causation.
And they can, Your Honor, but the actual response as even outlined and the disclosure by the defense specifically states that Dr. Sklar was not being designated to testify about causation. And in the deposition that occurred in the end of July, all that the testimony that he presented was about reasonableness and necessity. And he specifically stated that he was not making an opinion as to causation.
Mr. Montrose?
My response to that would be I didn't see this case law cited in the motion to quash the depot. And I feel like if that case says that, then that should be really important. And in there, this part about not talking about reasonableness and necessity was just the very end of the motion to quash. It was about 7 lines, and I didn't see any cases cited in there unless I missed it. I didn't have an opportunity to research that specific case we're saying says that.
And Your Honor, I will also confirm, or I will agree that in our motion to quash, it does not specifically address that case law. The motion to quash, I believe, was filed a couple days before the actual deposition. We were under the impression that the deposition had been pulled prior to the deposition actually, or the scheduling of the deposition occurred prior to the Rule 11 agreement. We never got confirmation in emails that we were sending to opposing counsel as to the deposition being pulled. And so we had to file a motion to quash as quick as we could to get that at least filed prior to the deposition that was scheduled. We were unable to obtain a hearing date prior to the deposition. But I will hold out to you that the Fifth Court of Appeals, this case law specifically outlines, and opposing counsel should be aware of this case because his expert, Dr. Sklar, is the same expert that was withheld from testifying in this Ten Hagen excavating case.
What? Okay, so let me make sure I kind of understand where we are. So Sklar was designated. Sklar had filed the counter affidavit. Defendants agreed to withdraw the counter affidavit. Then Sklar, but Sklar was noticed for deposition. In here, it doesn't show what the designation was. You say what the requirements for designation are, but you don't show what his designation was. Is it attached or something?
I believe it should be attached, Your Honor, in terms of the disclosure or their response to disclosures.
Let me see.
And it's a very
Okay.
short statement there, which just says, if any, nature and extent of reasonableness and necessity.
Okay, the nature side of answer, if any. I mean, that's really vague. I mean, what makes sense to me, I think, is that this really is an approach. I mean, the deposition's already occurred, so to quash it now is kind of too late. What it makes sense to me is to do a line and page designation for trial, and we'll figure out what is. I don't think I've read Ten Hagen the same way you have, but I'll be glad to look at it again. I don't think it's quite that broad, but I'll look at it again. It's not cited in your briefing, and so it's been a while since I read Ten Hagen. But if that's the case, then if you're right about that, then reasonable necessity would come out. That doesn't mean that the whole witness is struck.
Correct, Your Honor. And according to Ten Hagen, the holding, the witness isn't completely struck. And in fact, in Ten Hagen, the doctor was able to talk about prior medical care and pre-existing medical conditions, but that is the basis that doctor had been disclosed to testify about. That same doctor is this doctor here, Dr. Sklar.
Again, then that would need to be done as part of a line and page designation at the time of trial, and we just have to figure out what part of the testimony would come in and what wouldn't. Is the entire transcript attached to here?
No, Your Honor.
Sure.
The deposition probably occurred the last week of July. I don't believe it's available yet.
Okay.
Your Honor, if I understand what you're saying, you're not granting or denying the motion to quash because it's moot at this time?
Yeah, I would say that's true.
And,
Okay.
and Your Honor, and I guess we're still here then trying to present our motion to strike based upon the merits of that motion. Because
Well, there's two issues here. There's, do I strike the counter affidavits? Yes, I'll strike the counter affidavits because he agreed to withdraw them. So The second issue is what portion of the testimony comes in and what portion doesn't. Those are two separate issues.
And that I understand, Your Honor, but in terms of procedure, the cost benefit of the 1801 and the statute and the nature here is to prevent us from having to go through these costly depositions or presenting this other expert or bringing
The purpose of I disagree. Hey, you know, I'm a huge proponent of 18.01. I probably strike more counter affidavits than just about any judge here. But one thing I will say is the counter affidavits, the ability to file a counter affidavit and the ability for the defendant's expert to testify are two separate issues. 18.01 was intended to allow the plaintiff to be able to present his case without having to call a doctor live, which you're going to be able to do if you want to. That doesn't prevent, there's nothing in 18.01 that prevents the defendant's doctor from testifying if they want to, if, you know, assuming it gets by some Daubert, but there's two different standards. There's Daubert for the issue of causation, for an issue of testimony, and there's 18.01 and Turner v. Peril and all those other cases on the issue of the motion to strike. So I just think it's apples and oranges. So,
and you're correct, Your Honor. I guess I'm just in terms of procedure to forego the motion to strike as part of a Rule 11 agreement, and now to not sign the Rule 11 agreement or return it, and then not respond to any of our requests about the necessity of moving forward.
Mr. Montrose, though, has admitted on the record that he agreed to withdraw those counter affidavits. I mean,
okay.
Yes, sir. Just for the record, it was Mr. Kiramidas, but it was our firm. Yes, sir.
agreed to withdraw it. So you carried the day. I mean,
Understood, Your Honor.
I rarely have people argue as much as you are when you actually win the motion. But yeah, of course, it's going to be struck by agreement. Just get me an order that says that. And as to the motion to quash, the court's going to rule that it's moot.
Okay. I believe we presented motions to or orders on the motions to strike, and then yes, we will deal with page line designation and timeliness.
When is this case set for trial?
End of September, Your Honor.
You saw the Supreme Court's new order. Do you want to go ahead and reset it now, or do you want to wait?
There's another there's an intervener, Your Honor. So in terms of my client, we are ready for trial. I believe there are still a couple more depositions that may. Eric, is that correct? Does intervener have anyone else to present?
I believe he still has some affidavits he needs to get in, so okay. I don't think we should reset it without talking to him first.
Okay, I'm happy to reset it. It's not going to go to trial that day.
Understood.
One thing that I am strongly considering is, because we don't have any idea when this is going to be over, is if we reset this to next year, which is what we're doing with most of these car wreck cases, if we don't have a cure or some way to do jury trials by then, I am looking at Zoom trials. So I don't like Zoom trials, but it is something I'm considering for cases in 2021, not now, but for cases in 2021. So just be aware of that's a possibility.
Yes,
understood, Your Honor. Would you like us to file it as an agreed motion to strike the order, or an agreed order on the motion to strike? Or just...
I assume Mr. Montrose will live up to his word, which and he will sign it as an agreed motion, agreed order.
Yes.
Okay. Agreed order just as to the striking, not as to everything else.
Yes, sir.
All right. Anything else, guys?
Nothing further, Your Honor.
Nothing further from me.
Thank you, guys. You have a great day, and we will see you soon.